You're listening to the Valley Current.
Usually, like when we talk about getting a medical diagnosis, there's this comforting expectation of sheer precision.
Right, it's a very binary system.
Exactly. You fall, your arm hurts, you go to the hospital, and the x-ray shows a jagged white line across the bone.
You're either broken or you're not.
Yeah. The doctor points at the screen and says, there it is, that's the break. It's visible, it's categorical, and you know exactly what needs to be fixed.
I mean, we love that kind of certainty.
But then, you take a step into the realm of high-stakes, multi-billion-dollar antitrust law, and you quickly realize that the x-ray machine is just, completely useless.
It's worse than useless, honestly.
Right. You're looking at a legal landscape that is incredibly murky. The definition of a broken market depends entirely on who is holding the chart.
Which is exactly what we are seeing play out right now.
Today, we're going to navigate the absolute depths of those muddy waters for you. We're doing a deep dive into a monumental legal clash that is unfolding right now in late May of 2026.
And this is truly over the future of the internet itself.
It really is. To make sense of this, we are pulling from an incredibly detailed piece of source material. We have a comprehensive newsletter published on May 22, 2026.
Authored by Jack Russo from Computer Law Group, LLP, right?
Yes, exactly. Our mission for this deep dive is to take Google's massive 111-page appeal to the D.C. Circuit Court against a landmark antitrust ruling and figure out exactly why the trial judge's initial decision might be practically bulletproof.
Which the newsletter actually calls building appellate armor.
Appellate armor. I love that term. We are going to break down exactly how that armor was forged. Because this isn't just about one company's profit margins, is it?
Oh, not at all. I mean, this is a clash that is fundamentally going to define artificial intelligence, digital advertising, and really the exact rules of engagement for how the biggest tech platforms are allowed to operate.
So to appreciate the architecture of this appeal, we have to look at the foundation.
Right, which takes us back to a grueling 9-week bench trial.
And just to clarify, a bench trial means there was no jury, right?
Exactly. Just the judge acting as the sole finder of fact, U.S. District Judge Amit Mehta.
Okay, so Judge Mehta issued this massive liability opinion back in August of 2024. And he found Google definitively liable for monopoly maintenance.
Yeah. Then, jumping forward to late 2025, he handed down his remedies.
The punishment, basically.
Right, the actual structural or behavioral punishment meant to fix the monopoly. And now in 2026, both Google and the Department of Justice are cross-appealing.
Which, tells you something fascinating right off the bat. The judge's ruling is infuriating both the patient and the doctors.
Yeah, nobody is happy.
The government thinks the medicine wasn't strong enough, and the company thinks they didn't even need a prescription.
It is a perfect storm of dissatisfaction. But, that usually means the judge was meticulously careful.
Playing it right down the middle. Let's actually look at the mechanics of that carefulness. Let's start with the liability opinion from August 2024.
Okay, let's unpack it.
This document is 286 pages long, and its core conclusion is that Google is a monopolist under Section 2 of the Sherman Act.
Which is a huge label to attach to a company.
Right. Now, for anyone who hasn't been to law school, what does Section 2 of the Sherman Act actually prohibit? Because just being a big, successful company isn't illegal.
Right. And that is the critical distinction in antitrust law. The Sherman Antitrust Act dates all the way back to 1890.
Wow, 1890. So railroads and oil trusts.
Exactly. Designed to break up the massive trusts of that era. But Section 2 specifically targets the act of monopolization. It doesn't say that having a monopoly is inherently illegal.
So I invent something amazing and everyone buys it?
If you build a better mousetrap and everyone in the world buys it, you have a monopoly. But you earned it fairly. What Section 2 prohibits is the maintenance or acquisition of a monopoly through exclusionary or predatory conduct.
Ah, okay. So you cannot use your sheer size and power to artificially block other people from competing with you.
Precisely. You can't put a giant boulder in front of the other mousetrap factories.
And the numbers Judge Mehta looked at certainly proved the size and power part of that equation.
They were staggering.
Yeah, he found that Google holds an 89.2% share in general search services. But when you move over to mobile devices, like the phones in everyone's pockets, Google's share jumps to nearly 95%.
Nearly 95%. That's almost the entire mobile ecosystem.
It's wild. And the trial record also established that this monopoly extends directly into the market for general search text advertising, where their market share is similarly in the high 90s.
And see, the sheer volume of those market shares satisfies the very first requirement of a Section 2 claim. You have to actually possess monopoly power in a relevant market.
So they checked that box easily. But reading through the analysis of the trial in the newsletter, there's a really surprising twist.
Right, about what the DOJ actually won.
Yeah. The Department of Justice brought this massive, sprawling case. They were attempting to prove that Google was illegally dominating all sorts of different markets.
They threw everything at the wall.
But Judge Mehta explicitly rejected a huge portion of what the DOJ was asking for. For instance, the DOJ wanted him to define the market as all general search advertising.
But he didn't do that.
He said no. He limited the liabilities specifically to text ads. Now, if you are a judge trying to rein in a tech giant, why would you artificially shrink the government's victory like that?
Well, because a trial judge's biggest fear is getting overturned on appeal.
Ah, the appellate armor.
Exactly. That's where the appellate armor concept comes into play. If Judge Mehta had agreed with the DOJ and said, yes, Google monopolizes the entire digital advertising market, that's risky.
Because an appeals court might look at that and say, wait a minute.
Right. They'd look at the record, see competitors like Amazon or Meta taking huge chunks of ad revenue across the internet, and they might throw out the entire ruling for being overly broad.
So by tightening the lens, he ensures the ruling actually sticks.
Precisely. By limiting liability strictly to the very specific market that the trial record incontrovertibly supported, which is text ads specifically generated from search queries, he avoided judicial overreach.
He essentially told the DOJ, look, I see the monopoly in this specific vertical.
Yeah, but I do not see the economic evidence to prove you have market power across the entire universe of online advertising.
And he didn't just trim the market definition, he threw out several of the plaintiff's specific theories of harm.
He really cleaned house on some of the fringe arguments.
Like he rejected the DOJ's tying claims. What is a tying claim, mechanically speaking?
So a tying claim is when a company uses its dominance in one product to force consumers to buy or use a second distinct product.
Okay, give me an example of that.
Imagine a car dealership that has a total monopoly on selling cars in your town. And they tell you that you can only buy a car if you also sign a 10-year contract for their proprietary brand of tires.
Oh, so they are tying the two products together.
Right. They are illegally leveraging their monopoly from the car market to force themselves into the tire market.
So in this Google case, the DOJ was arguing that Google tied its search engine to the Chrome browser.
Yes. The argument was that Google used its various assets to force the adoption of Chrome, or vice versa.
But Judge Mehta didn't buy it.
He looked at the evidence and concluded the DOJ simply didn't prove that consumers were being coerced in a way that violated antitrust law. I mean, at the end of the day, people genuinely just wanted to use Chrome.
It's just a popular product.
Yeah.
He also threw out something called a duty-to-deal theory. This was regarding a platform called SA360.
Right. Search Ads 360.
What is that?
SA360 is a management tool that advertisers use to buy ads across multiple different search engines at once. It's a dashboard, basically.
Okay. And what was the argument there?
The plaintiff states argued that Google intentionally delayed implementing features in SA360 that would have made it easier for advertisers to buy ads on Microsoft's Bing.
So they were saying Google dragged its feet to hurt Bing.
Exactly. They argued Google had a duty to make their tool work better with a competitor's product.
That sounds like a really tough argument to win. Does the law actually force you to help your competitor?
Generally, no. And that is exactly what Judge Mehta ruled. You know, antitrust law is designed to protect competition itself, not individual competitors.
Right. It's not there to make Bing's life easier.
Exactly. Unless there are very specific, rare circumstances, a company has no legal duty to redesign its own products just to help out a rival.
So by throwing out the tying claims and the SA360 theory, Judge Mehta demonstrated to the higher courts that he was an impartial referee.
He didn't just rubber stamp the government's narrative, he demanded rigorous economic proof for every single claim.
Which makes the areas where he did find them liable that much harder to overturn. The armor gets thicker.
Yes, exactly.
Before we get to the core of what they were actually found liable for, there's one more piece of the liability phase that we have to talk about.
The spoliation issue.
Yes. Because this has massive implications for anyone working in a corporate environment today.
It is a fascinating procedural issue, and it ended up generating one of the most severe warnings in the entire 286-page opinion.
Right. So during the discovery phase of the trial, the DOJ found out that Google employees frequently used internal chat applications.
And these chats were set to auto-delete messages after a short period.
Like often 24 hours.
Yeah.
And crucially, even when the company was under a legal litigation hold, which is a formal order to preserve all documents because you were being sued, the burden was placed on individual employees.
Right. An engineer would have to manually click a button to save a chat history if they thought it was relevant to the lawsuit.
Which is wild. So the DOJ wanted Judge Mehta to formally sanction Google for spoliation.
Which is the legal term for destroying or failing to preserve evidence.
So what did the judge do? Did he sanction them?
Well, he ultimately declined to issue a formal sanction. Like, he didn't instruct himself to just assume all the deleted chats contain terrible, incriminating things about Google.
But he didn't let them off the hook rhetorically.
Not at all. He included a quote in the 2024 opinion that, I think every corporate general counsel has probably printed out and framed by now.
I have the quote right here. He wrote, "Google avoided sanctions in this case. It may not be so lucky in the next one. Any company that puts the onus on its employees to identify and preserve relevant evidence does so at its own peril."
That is a chilling warning. And if you look at the mechanics of modern corporate communication, that ruling changes everything.
Because everyone uses these chat apps now.
Yeah. For the last decade, we've seen a massive shift away from formal email toward ephemeral messaging platforms like Slack, Microsoft Teams, or Google Chat.
Companies like the idea that these casual water cooler conversations didn't live on a server forever.
Yeah, waiting to be subpoenaed 10 years later. But Mehta is essentially saying that relying on an auto-delete function when you know you're under investigation is unacceptable.
It's just not going to fly anymore.
Exactly. You can no longer use the casual nature of a chat app as a shield against the discovery process.
So if your corporate policy requires an individual engineer to remember to turn off the auto-delete function in the middle of a casual conversation.
Just in case it might be relevant to a future antitrust lawsuit. Yeah, the courts are going to view that as a deliberate system designed to destroy evidence.
So the days of hiding behind disappearing messages are completely over. Okay, so that sets the stage. We know Google has a monopoly in search and text ads.
Right.
We know Mehta threw out the fringe theories. And we know he issued a severe warning on corporate chats. But how did Google actually maintain this monopoly illegally?
That brings us to the core of the conduct that actually broke the law.
Right, the staggering cost of default placements.
To understand the mechanics of this monopoly, you really just have to follow the money. And the sheer scale of the money involved here is breathtaking.
It really is. Based on the trial testimony highlighted in the newsletter, back in 2014, Google was paying various partners about $7.1 billion a year to be the default search engine on their devices and browsers.
Which is already a massive number.
But by 2021, that number had exploded to $26.3 billion in a single year.
In 1 year.
It feels like Google looked at the landscape and realized that the best way to win the race wasn't just to be the fastest runner. The best way to guarantee a win was to pay the track owner to buy the exclusive rights to the starting line.
So nobody else was even allowed to step onto the track.
Exactly. Does that analogy hold up legally?
That analogy captures the exact economic reality of the situation. Look, running faster than everyone else is legal. That is what antitrust law calls competition on the merits.
Having the best algorithm, the cleanest interface.
The most relevant results, all of that is perfectly fine. But when you spend $26.3 billion to ensure that consumers never even have the opportunity to hear the starting pistol for a competitor...
That's where Section 2 gets triggered.
Exactly. You're buying the starting line.
And when we talk about buying the starting line, the undisputed crown jewel of that strategy is Apple.
Oh, absolutely. The Information Services Agreement, commonly referred to as the ISA, between Google and Apple was really the centerpiece of the DOJ's case.
What were the terms of that deal?
Under the terms of the ISA, Google paid Apple approximately $20 billion in the year 2022 alone.
$20 billion.
And that payment was for one specific privilege: to be the default out-of-the-box search engine on Apple's Safari browser across all iPhones, iPads, and Mac computers.
$20 billion. For context, there are entire countries with GDPs smaller than what Google pays Apple just to be the default setting on a phone?
It's hard to even conceptualize, and the context gets even more intense when you look at Apple's financials. That $20 billion payment represented roughly 36% of all the search ad revenue generated through Safari.
So it was a revenue share.
Yes. The mechanics of the deal were a revenue share. Google wasn't just handing Apple a flat fee. They were giving Apple a massive cut of the profits generated by every single person who searched for something on an iPhone and clicked on an ad.
Which completely aligns their incentives. If Apple makes a percentage of Google's ad revenue, Apple genuinely wants people to use Google more.
Exactly. They are partners in the monopoly.
But wait, I'm stuck on something here. Let me play devil's advocate. Let's look at this from a completely standard business perspective.
Okay, lay it out.
If I walk into a grocery store, a giant brand like Coca-Cola pays the supermarket for the premium shelf space, right? They buy the end caps, they buy the eye-level placement in the aisle.
Right, slotting fees.
Yeah. Brands pay for placement all the time, and nobody arrests the store manager. If Apple looked at the landscape, saw that consumers widely prefer Google anyway, and decided to sell them that premium shelf space on the iPhone, why is that illegal?
Well, you've just articulated the exact defense Google is mounting on appeal.
Really?
Yes. They argue this is standard, vigorous competition for distribution. But Judge Mehta rejected the grocery store analogy. Because a mobile operating system isn't a grocery store. Think about it. If you don't like the soda selection at one grocery store, you can just drive across the street to another one.
Sure.
But in the mobile phone market, there are only two doors to the internet. Apple's iOS and Google's own Android.
Oh, wow. So if you buy the only two doors, the entire building is sealed off.
Exactly. The scale is completely different. Judge Mehta identified 3 distinct mechanical anti-competitive effects caused by these billion-dollar payments.
Okay, let's go through them. What's the first one?
The first is market foreclosure. By securing exclusive defaults with Apple, as well as with Mozilla, Samsung, and Android device manufacturers, Google essentially captured roughly half of all search queries in the United States.
Before anyone else even had a chance.
Right, before any rival even had a chance to compete for them.
Half the market is locked up before the race even starts. That's huge.
Yeah.
What is the second effect?
The second effect is preventing rivals from achieving scale. In the search engine business, scale isn't just about revenue. It is the fundamental raw material of the product itself.
What do you mean by raw material?
Data. The more people search, the more data the engine collects on which links people actually click. That user interaction data trains the algorithms to provide better results.
And better results attract more users.
Exactly. It is a massive flywheel.
So by hoarding all the default traffic, Google is actively denying competitors like Microsoft Bing or DuckDuckGo the oxygen, the query volume. They desperately need to improve their own search quality.
Spot on. A competitor can't improve their algorithm without data, but they can't get data because Google bought all the default access points.
It's a vicious cycle for the competitors.
It is. And that leads directly to Judge Mehta's third anti-competitive effect: diminished incentives for innovation. And this is where the Apple revenue share agreement becomes so legally toxic.
Because Apple has zero financial reason to invent their own search engine.
Precisely. Apple has the capital, they have the engineering talent, and they have the captive user base to build a search engine that could rival Google.
They could absolutely do it.
But why would they spend billions of dollars in R&D and take on all that operational risk when Google is perfectly willing to just hand them $20 billion a year in pure profit to simply not compete?
Just to sit on their hands.
Right. During the trial, a declaration from Apple executive Eddie Q from December 2024 was presented, and it explicitly confirmed that Apple has no plans to build a search engine of its own.
Google essentially paid their most dangerous potential rival to stay out of the market.
That's how the judge saw it.
But legally speaking, how does a judge weigh these anti-competitive harms against the very real fact that Google is, frankly, just a really good search engine? Because Meta didn't deny that Google is a great product.
He didn't deny it at all. In fact, he actively praised their engineering.
So how do you balance that?
To navigate this tension, Judge Mehta utilized a highly structured legal mechanism from the D.C. Circuit Court known as the Microsoft III burden-shifting framework.
Microsoft III. So this stems from the landmark antitrust case against Microsoft back in 2001.
Yes, exactly. Involving the browser wars between Internet Explorer and Netscape.
Okay, so how does a burden-shifting framework actually operate in a courtroom, like step by step?
It works in 3 distinct steps. Step 1, The plaintiff, in this case the DOJ, has the initial burden to demonstrate that the monopolist's conduct actually caused an anti-competitive effect.
You have to prove the harm.
Right. They have to prove the market foreclosure, the denial of scale, the stifled innovation.
Which they did by showing the $26 billion in payments and the locked-up default placements.
Correct. Once the DOJ proves that, we move to step 2. The burden shifts to the defendant, Google.
Okay, what does Google have to do?
Google has to provide a non-pretextual, pro-competitive justification for their conduct. They have to prove that they didn't do this just to crush rivals, but for a legitimate business reason that ultimately benefits consumers.
And this is where Google says, look, we pay for placement because we want users to have a frictionless experience getting to the search engine they already prefer. Our product is superior, and that is why Apple chooses us.
Yes. And this is the crucial part. Judge Mehta actually agreed with Google at step 2.
He did.
He did. He explicitly credited their product superiority. He acknowledged that they have brilliant engineers, they iterate constantly, and they have made incredibly shrewd business decisions over the past 20 years.
Wait, if he agrees their product is better and that users want it, how do they end up losing the case?
Because of step 3. The burden shifts back to the plaintiff to rebut the defendant's justification.
It goes back to the DOJ.
Exactly. The DOJ had to prove that the anti-competitive harm caused by the conduct vastly outweighs the pro-competitive benefits. And Judge Mehta ultimately concluded that while Google's product is superior, the sheer scale, duration, and exclusivity of these multi-billion-dollar contracts went far beyond mere competition on the merits.
I see. So they didn't just win the game, they destroyed the playing field.
That's a great way to put it.
They built a moat so deep and so wide that even if a startup built a radically better search engine tomorrow, they would have absolutely no mechanism to get it in front of users on a mobile device.
Exactly. The exclusionary contracts actively harmed the competitive process itself, regardless of how good the underlying product was.
So that establishes the crime.
Yeah.
Google used exclusive default contracts to illegally maintain a monopoly. Now we have to pivot to the punishment.
The remedies phase.
Right. In September of 2025, Judge Mehta issued a 230-page remedies opinion. Now, logically, if a company is found guilty of a massive, multi-decade antitrust violation, you would expect the financial markets to panic.
You'd expect a massive sell-off.
You would expect Alphabet's stock to plummet. But that isn't what happened. When the remedies opinion dropped, Alphabet stock actually jumped 8% in after-hours trading.
Yeah, the market loved it.
Why were investors cheering for a guilty verdict?
Well, investors weren't cheering the verdict. They were cheering the survival of the company's core architecture.
They dodged a bullet.
Exactly. The market had been terrified of the ultimate corporate death penalty, which is a structural breakup.
And the DOJ wanted that, right?
They did. Throughout the remedies phase, the DOJ's signature demand was the forced divestiture of the Chrome web browser, and they heavily implied they might want to spin off the Android operating system as well.
They wanted to fundamentally chop Google into separate competing pieces.
But Judge Mehta looked at that request and said no.
Why did he reject the breakup? If they are an illegal monopoly, why not just break them up?
Because in antitrust law, the remedy must be directly tethered to the specific conduct that was found to be illegal. You can't just punish a company for being big. You have to fix the specific mechanism of the crime.
So the punishment has to fit the exact crime.
Right. Judge Mehta wrote that after overseeing 2 complete trials, the liability phase and the remedies phase, he could not find that Google's sheer market dominance was sufficiently attributable to its illegal conduct to justify a forced divestiture of incredibly successful products like Chrome or Android.
Let me make sure I'm tracing the logic here. The specific mechanism of the crime was the exclusive default contracts with Apple and Android manufacturers.
Correct.
The crime was not the invention or the operation of the Chrome browser itself. So ordering them to sell Chrome would be punishing them for something that wasn't actually part of the antitrust violation.
That is exactly the legal logic. Chrome and Android were certainly vehicles that benefited from the monopoly, but they were not the exclusionary weapons used to maintain it.
The weapon was the checkbook.
The weapon was the $26 billion in exclusive default payments. Judge Mehta felt that using a behavioral violation to justify a massive structural restructuring of the entire digital economy was judicial overreach.
So if he is not going to break them up, what does the actual punishment look like? What does Google literally have to do differently under this 6-year decree that was finalized in December 2025?
The decree is a highly calibrated, tightly drawn behavioral package. It fundamentally attacks the mechanisms of the moat.
Starting with the default deals.
Yes. First, it addresses the default deals. Google is still legally allowed to pay companies like Apple or Samsung for placement because, again, paying for shelf space isn't inherently illegal, but those contracts can no longer be exclusive.
Meaning Apple is now legally free to offer a choice screen or preload multiple search engines, even if Google is paying them.
Correct. Furthermore, the duration of these default contracts is strictly capped at 1 year.
Oh, that changes the dynamic.
Hugely.
Yeah.
Historically, Google would lock up these distribution channels for years at a time, making it impossible for a rival to even make a competing offer. Now, every single year, that real estate comes back onto the open market.
It forces Google to constantly compete for the space. And it opens the door for competitors to at least attempt to bid for the default position.
Exactly. It introduces friction into the monopoly.
That addresses the distribution moat. But earlier we talked about the data moat, the idea that competitors can't get the query volume needed to train their algorithms. How does the judge fix that without just forcing people to use a worse search engine?
This is where Judge Mehta introduced the most controversial part of the decree, the data sharing mandate.
A data sharing mandate.
Yes. Under the new rules, Google is legally required to share certain search index data and user interaction data with what the court calls qualified competitors, and they have to provide this data on reasonable commercial terms.
Wait, hold on. Google spends billions of dollars crawling the internet to build their search engine. They have to just give away their secret sauce to anyone who asks.
Not entirely. And understanding the technical distinction Judge Mehta made here is really crucial. The judge carefully divided Google's assets into two categories, the map and the compass.
Okay, unpack that analogy for me. What is the map?
Think of a search index like the ultimate microscopic card catalog of the entire internet. Google's web crawlers go out and read every single page, categorize the text, map the links, and build a massive, constantly updated database of what exists online.
Right.
Building that index costs billions of dollars in server infrastructure and compute power. It is an insurmountable barrier to entry for a startup.
A startup can't afford to crawl the whole internet, so that index is the map.
Yes. Judge Mehta is forcing Google to license access to that map. If you are a qualified competitor, you can pay Google to use their underlying index of the web.
But what is the compass?
What Google does not have to share is their source code, their proprietary ranking algorithms, or their specific advertising data. That is the compass. That is the secret recipe for how Google decides which page from the index is the most useful answer to your specific query.
Okay, so the logic is we will give the competitors the raw materials, the index, so they don't have to spend $10 billion crawling the web. But the competitors still have to build their own algorithms to sort that data better than Google does. It lowers the barrier to entry without just handing over the keys to the castle.
That's perfectly stated. It's about giving rivals the raw data they need to achieve scale while fiercely protecting Google's proprietary engineering innovations.
But who actually polices this? Because if I am Google, I am going to make the process of getting this data as miserable and expensive as legally possible.
Of course you would.
So who decides what a qualified competitor is, or what a reasonable commercial term looks like?
Recognizing that exact problem, the court mandated the creation of a technical committee to oversee compliance.
A technical committee?
Yes. This is actually a structural nod back to the Microsoft antitrust case from the early 2000s, which used a similar committee to ensure Microsoft was actually opening up windows to developers.
Who is on this committee?
This new committee will be comprised of independent experts in software engineering, artificial intelligence, economics, and data privacy.
So it's a team of auditors with deep technical knowledge.
Yes. And crucially, they will have confidential, under-the-hood access to Google's systems to ensure the company is playing by the rules, not dragging their feet, and offering fair syndication licenses on mandatory 5-year terms.
This all sounds very logical for traditional text search.
Yeah.
But, it's 2026. We cannot talk about search without talking about the massive elephant in the room, generative AI.
No, we can't.
I noticed the newsletter zeroes in on a very specific provision in the remedies regarding Gemini, Google's generative AI platform.
It is a critical, forward-looking detail. Judge Mehta understood that the definition of search is rapidly evolving.
So what did he do?
So he explicitly wrote into the decree that the exclusivity bans, meaning the rule that Google cannot pay to be the exclusive default, extend directly to the Gemini application and any future generative AI features Google builds into search.
The irony of this is just incredible to me.
It really is.
For the last 2 years, Google's main defense in the court of public opinion has been pointing at AI. They've been saying, look at ChatGPT, look at Claude. The market is incredibly dynamic. Our monopoly isn't durable. We are fighting for our lives against these new AI chatbots.
Right, don't regulate us. The market is already disrupting us.
They are actively using the existence of generative AI to argue that they aren't a monopoly anymore.
But that exact argument completely backfired in the remedies phase.
How so?
Because Judge Mehta listened to them, agreed that generative AI is a significant part of the future of search, and therefore concluded that his behavioral constraints must apply onto AI as well.
Oh, man.
He wants to prevent Google from using its existing search monopoly as a bridge to illegally conquer the emerging generative AI market.
It is a phenomenal double-edged sword.
Yeah.
AI is their best defense against liability, but it results in their newest, most important technology being shackled by a federal judge's data sharing mandates. Which brings us directly to the current moment. We have the crime, we have the punishment. Now we arrive at the counterattack.
The appeal.
Late Friday afternoon, on May 22, 2026, Google formally filed a 111-page opening brief with the D.C. Circuit Court of Appeals, seeking to overturn Judge Mehta's entire ruling.
They brought out the big guns for this.
The newsletter breaks this massive filing down into 5 core appeal arguments. Let's walk through the mechanics of how Google is trying to dismantle this case, starting with arguments 1 and 2. Myth-applied Section 2 and market gerrymandering.
So Google is not holding back. They have retained an absolute appellate dream team led by heavyweights like John Schmidtland and Donald Verrilli.
Serious lawyers.
Very serious. And their overarching rhetorical strategy is brilliant because they are using Judge Mehta's own words against him.
I saw this in the brief. They actually quoted the liability opinion back to the judge.
Yes, they did.
They wrote that Google won the market because it developed a superior search engine through hard work, bold innovation, and shrewd business decisions. That was Mehta's exact phrasing.
It is a highly deliberate, aggressive legal maneuver. They argue that the trial court fundamentally confused harm to specific competitors with harm to the overall competitive process.
So they're essentially telling the appellate judges, the trial court openly admitted that we won fair and square.
Right. We built a better product, and consumers overwhelmingly chose it. You cannot turn around and punish a wildly successful competitor simply because they won the race they were supposed to run.
And they tie that directly into their second argument. The accusation of market gerrymandering. What does gerrymandering mean in the context of antitrust economics?
Well, in politics, gerrymandering means drawing artificial district lines to guarantee a specific voting outcome.
Right.
In antitrust, market gerrymandering means artificially drawing the boundaries of a product market so narrowly that a company looks like a massive monopoly while ignoring all the actual competition happening just outside those artificial lines.
Okay, give me an analogy for that. Make it real for me.
Okay, imagine you own a highly successful vegan bakery. If the government defines the market as all food sold in the city, your market share is less than 1%. You are tiny.
Makes sense.
But if the government gerrymanders the definition and says the market is exclusively vegan, gluten-free cupcakes sold on Main Street, suddenly you have a 100% monopoly.
Ah. So Google is arguing that Judge Mehta gerrymandered the definition of search.
Exactly. Google argues that in 2026, it is economically absurd to define the market as just general text search.
Because they compete against everything now.
Right. They point out that they are fighting brutal battles for user attention against vertical search engines like Amazon for shopping, against social search like TikTok for local recommendations, and against AI assistants for complex queries.
So they're telling the appeals court, if you look out the window at the real world, we are fighting for our lives on a dozen fronts. The trial court artificially inflated our market share to 90% by simply ignoring reality.
Exactly. They drew a circle around the one specific thing we do best.
That is a compelling argument on its face. But the newsletter suggests that Google's strongest single legal shield is actually found in arguments 3 and 4, the exclusionary error and the Trinco defense.
This is where it gets incredibly philosophical.
I want to really take our time and dig into this because this touches on the very philosophy of innovation. What on earth is a Trinko defense?
To understand the Trinko defense, we have to travel back to 2004, to a massive Supreme Court case formerly known as Verizon Communications, Inc. v. Law Offices of Curtis v. Trinko, LLP.
Okay, Verizon v. Trinko.
The opinion was written by the late Justice Antonin Scalia, and it is arguably the most important precedent regarding when, if ever, an antitrust court can force a monopolist to share its private property with a rival.
Forced sharing. So this directly attacks Judge Mehta's remedy, forcing Google to share its search index data.
Precisely. In the Trinko case, which involved local telephone networks, Justice Scalia wrote a sweeping defense of the rights of a monopolist.
The defense of the monopolist?
Yes. He argued that the mere possession of monopoly power and the charging of monopoly prices is not only illegal, it is actually an important element of the free market system.
Wait, how is a monopoly an important element of the free market?
Because the opportunity to achieve a monopoly is what induces risk-taking that produces innovation.
The idea being, if there is no massive reward at the end of the rainbow, nobody is going to spend the billions of dollars to build the rainbow in the first place.
Exactly. And more specifically, Scalia warned that courts should be deeply cautious about forced sharing mandates. He wrote that compelling a firm to share the source of its advantage with rivals has uncertain virtue and is in some tension with the underlying purpose of antitrust law.
Let me trace the mechanics of that tension. Let's say I am Google.
Okay.
And I spend 20 years and tens of billions of dollars deploying web crawlers, laying undersea cables, and building data centers to map the entire internet. I created something incredibly valuable.
Right. You built the index.
If the federal government can suddenly step in and say, congratulations, you did such a good job that now you have to rent your index to your competitors at a cheap commercial rate, why would any company ever attempt a massive infrastructure project again? You are essentially subsidizing your own assassins.
You have perfectly summarized the core of the Trinko defense. Forced sharing might help rivals compete today, but it arguably punishes the innovator and severely discourages future investment across the entire economy.
It's a huge disincentive.
Google is leaning heavily on Scalia's logic to tell the D.C. Circuit that Judge Mehta's data sharing remedy crosses a bright, established legal line. They are arguing that under Supreme Court precedent, you simply cannot compel a private firm to socialize its proprietary assets.
And this philosophical argument leads directly into argument 5, the OpenAI defense, which brings this entire theoretical legal debate crashing into the reality of 2026.
It really does. Google's appellate brief essentially says, if you want proof that you don't need to force us to share our data for competition to thrive, just look at OpenAI.
The newsletter highlights the staggering metrics on this. As of early 2026, OpenAI has roughly 900 million weekly active users.
900 million.
They are processing billions of prompts a day. So Google is holding them up as the ultimate proof of a dynamic market.
Yes. Google frames the competitors who would rely on Judge Mehta's data sharing mandate as ersatz rivals.
Ersatz, meaning fake or inferior.
Right. Ersatz meaning artificial or an inferior substitute. They are arguing that a company that only exists because a judge ordered Google to hand over its index isn't a real competitor. They are just a parasite.
And OpenAI is the counterexample.
Yes. True. Natural competitors like OpenAI, which didn't even exist during the years Google was allegedly committing these antitrust violations, have managed to achieve massive scale and wild success without needing a court-ordered data handout from Google.
Okay, I have to stop and unpack this OpenAI argument because it feels like a bit of a sleight of hand. Let's use an analogy.
I'm ready.
Google is essentially standing in the middle of a massive traffic jam that they themselves caused by buying up all the roads. And while sitting in the traffic jam, they point up at a passing rocket ship at OpenAI and yell, "Look, transportation is totally fine. Look how fast things are moving up there."
That's a great visual.
But does the existence of a rocket ship flying overhead actually fix the traffic jam on the ground? Does OpenAI's success in answering complex AI prompts actually negate Google's monopoly in this specific market of traditional text search?
That is the exact counter-argument the DOJ will make. And it hinges entirely on how you define the product market.
Right.
An AI chatbot writing a Python script or summarizing a historical event is an incredible technological achievement. It is a rocket ship.
Right.
But is it a functional substitute for a consumer pulling out their phone, typing "emergency plumbers open now near me," and clicking on a text ad with a phone number?
Probably not. The chatbot doesn't know who is open down the street right now. It doesn't have local ad inventory.
Exactly. If the answer is no. If AI chatbots serve a fundamentally different consumer need than traditional navigational search, then OpenAI's massive success, while impressive, doesn't actually erode Google's monopoly power in the specific market Judge Mehta defined.
The rocket ship is flying in a completely different layer of the atmosphere.
It doesn't solve the traffic jam on the ground where local advertising happens.
Which brings us to the most complex part of this entire saga, because Google isn't just fighting the judge, they're fighting the government, and the government is fighting back.
The cross-appeal.
Let's move into the cross-appeal dynamic and analyze this appellate armor. In February 2026, the Department of Justice filed their own cross-appeal.
Right. They are still furious that Judge Mehta didn't break the company apart.
And they are officially asking the DC Circuit Court to force the sale of the Chrome browser.
And this is where Jack Russo's newsletter provides incredible value, because he moves past the rhetoric and lays out the actual legal probabilities.
And the probabilities suggest the DOJ is facing an incredibly steep uphill battle.
Very steep. Let's break down the odds.
Let's start with the liability finding. The ruling that Google is an illegal monopoly. What are the odds that survives the appeal?
The newsletter estimates the probability of the DC Circuit affirming Judge Mehta's liability finding at a very high 70 to 75%.
Wow. Why is it so likely to survive when Google has such a strong legal team and arguments like Trinco?
It comes down to the mechanics of appellate review. First, as we discussed, Judge Mehta didn't invent a new legal theory to convict Google. He meticulously applied the DC Circuit's own framework from the Microsoft the Third case.
Right, the three-step burden shifting.
Exactly. Asking a panel of appellate judges to overturn a trial judge who faithfully followed their own specific instructions is structurally very difficult.
We told you to use this formula, you use the formula perfectly, but we don't like the answer? That is a tough argument for Google to make.
Exactly. Second, and perhaps more importantly, is the standard of review applied to factual findings.
What does that mean?
In an appeal, the appellate court does not conduct a new trial. They don't hear from witnesses again. For all the factual determinations Judge Mehta made, like the definition of the market or the intent behind the Apple contracts, the appeals court must apply the clearly erroneous standard.
What does clearly erroneous actually mean in practice?
It is an incredibly deferential standard. It means the appeals court cannot overturn a fact just because they might have interpreted the evidence differently.
Oh, so they have to prove he was wildly wrong.
Yes. To overturn a fact, the reviewing court must look at the record and be left with the definite and firm conviction that a massive mistake was committed. The trial judge essentially has to be completely disconnected from reality.
And Mehta was not.
Right. Given that Judge Mehta spent 9 weeks listening to testimony, reviewing millions of pages of documents, and wrote a 286-page meticulous justification for his findings, proving that his grasp of the facts was clearly erroneous is almost impossible.
So the liability armor is thick. But what about the DOJ's cross-appeal? What are the odds that the appeals court listens to the government and decides to order the forced sale of the Chrome browser?
The newsletter places the probability of a forced divestiture of Chrome at less than 10%.
Less than 10%. Why is it essentially dead on arrival?
Again, it comes back to the DC Circuit's own precedents, specifically the history of the Microsoft case.
What happened with Microsoft on appeal?
In 2001, the trial judge in the Microsoft case actually did order the structural breakup of the company. But the DC Circuit Court of Appeals reversed that breakup.
Yeah, and did it.
Yes. They established a historical precedent that they deeply disfavored tearing companies apart in monopoly maintenance cases, especially when the assets the government wants to divest, like the Chrome browser today or the Windows operating system back then, were not the actual exclusionary tools used to commit the antitrust violation.
The tool was the money, not the browser. So the DOJ is basically asking the DC Circuit to ignore its own historical reluctance to break up tech companies.
Correct. The DC Circuit prefers surgical behavioral remedies, which means Judge Mehta's calibrated middle path approach is perfectly aligned with the appellate court's historical temperament.
So if the DC Circuit upholds the middle path, affirming the liability but rejecting the breakup, where does this inevitably end up?
All roads in a case of this magnitude lead to the United States Supreme Court.
And what's the timeline on that?
The newsletter projects that the DC Circuit will issue its ruling in mid-2027, and the final resolution at the Supreme Court timeline will stretch into 2028 or 2029.
But the Supreme Court doesn't have to take the case, right? What are the actual odds they grant a review?
The legal term for the Supreme Court agreeing to hear an appeal is granting a writ of certiorari, or cert for short.
Right.
The Supreme Court receives thousands of petitions a year and usually only grants cert to about 4% of them. It is a tiny baseline rate.
But what are the odds for this case?
Jack Russo's analysis gives this specific case a 50 to 60% chance of being granted.
That is a massive jump from 4%. Why is this case so special?
Because the legal questions it raises are entirely novel and they threaten to fracture the uniform application of federal law.
Unpack that for me. What are the specific questions?
First, you have a Supreme Court currently composed of conservative justices who are generally skeptical of expansive government antitrust enforcement and highly protective of private property rights.
So they will definitely want to look at the Trinco issue.
Exactly. They are going to be intensely interested in reviewing the Trinco question regarding whether a judge can force a company to share its proprietary data. They will want to weigh in on the limits of forced sharing.
What else?
Second, they're going to be interested in how traditional antitrust frameworks apply to modern two-sided digital markets where the consumer doesn't actually pay a financial price for the product.
Because we don't pay to use Google.
Right. And finally, the Supreme Court is going to want to establish the ground rules for how antitrust remedies should function in an era dominated by generative AI. They cannot leave a question of this magnitude unresolved at the circuit court level.
Okay, so we have mapped the trajectory in Washington, D.C. But as we zoom out, we realize that Google is not just fighting a single battle. They're fighting a multi-front global war.
It is a truly global chessboard.
Let's look at the broader landscape, because Judge Mehta is far from the only judge currently holding a gavel over Google's head.
Not at all. In fact, right across the river in the Eastern District of Virginia, U.S. District Judge Leonie M. Brinkema presided over a completely separate antitrust case brought by the DOJ.
This one focusing not on search, but on Google's advertising technology stack, right?
Yes. In April of 2025, Judge Brinkema also found Google liable for monopolization. And as of our current timeline in late May 2026, her remedies opinion is expected imminently.
And what is the DOJ asking for in that Virginia case?
They're seeking the structural divestiture of Google's AdX platform, the actual marketplace where digital ads are bought and sold. So while Mehta rejected a breakup, Brinkema might order one.
That is incredible pressure. And what about the App Store side of the business?
That is another critical vulnerability. Remember the Epic Games antitrust lawsuit regarding the Google Play Store?
Yeah, Epic Games, the makers of Fortnite.
Exactly. In July of 2025, the Ninth Circuit Court of Appeals out in California unanimously upheld a jury verdict finding Google liable for antitrust violations in app distribution.
Why is that specific Ninth Circuit ruling so important to the D.C. appeal we are talking about today?
Because in the Epic Games case, the Ninth Circuit affirmed incredibly aggressive, forward-looking affirmative remedies despite Google raising the exact same Trinco defense they're using in D.C.
Wait.
Google told the Ninth Circuit, "You can't force us to open the Play Store. It violates Trinco." The Ninth Circuit said, "Yes, we can."
Oh, so you now have one federal appeals court that has already explicitly rejected Google's best legal defense.
Exactly. This creates what is known as a circuit split, where different regions of the country are applying federal law differently.
And that's a big deal.
A circuit split is the #1 reason the Supreme Court decides to grant certiorari and take a case, because federal law has to be uniform across the country.
And we haven't even crossed the Atlantic yet. The European Commission has been relentless. They handed down a €2.95 billion fine against Google's ad tech practices back in September of 2025.
Yes, the regulatory pressure in the EU is immense.
So, looking at this entire board, multiple federal judges finding them liable, appeals courts upholding remedies, Europe levying multi-billion-dollar fines, the DOJ trying to chop off Chrome and AdX. I have to interject here.
Yeah.
Common sense dictates that a company facing this level of coordinated global legal assault must be bleeding. The internal panic must be palpable. Are they in an existential crisis?
Well, on paper, in the legal filings, they describe it as an existential threat. But if you look at the actual financial reality, the story is completely different.
Let's talk numbers.
Alphabet reported its Q1 2026 calendar year results just a few weeks ago, in April of 2026. Their consolidated revenue for a single quarter was $109.9 billion.
Almost $110 billion in 3 months. That is absurd.
Yes, and that is up 22% year over year. More importantly, their core search advertising revenue didn't just hold steady, It actually accelerated.
Wait, how is that possible? Everyone has been saying that AI chatbots are going to destroy traditional search.
That was the dominant bear thesis, the idea that legal woes combined with AI disruption would crush Google's margins.
But it didn't.
No. CEO Sundar Pichai told Wall Street analysts on the earnings call that their new AI overviews, the generative AI summaries they integrated directly into the top of traditional search results, are monetizing at rates similar to, and sometimes better than, traditional link-based search.
So the consumers are still searching. They're just reading the AI summary instead of clicking a link.
Exactly. And Google is still serving ads against that attention. The legal threats they are facing are massive generational challenges. But the fundamental financial engine of the company remains completely unfazed.
It's a money printing machine.
They are generating so much cash that they are projecting massive continuous increases in capital expenditure to build the data centers required to fuel their AI infrastructure. They are fighting for their lives in the courtroom while printing record profits in the market.
That is a staggering dichotomy. So how do we synthesize all of this high-level legal maneuvering and multi-billion-dollar financial data into something practical?
We need to look at the playbook.
Exactly. What does this mean for the listener? Let's bring this down to earth and look at actionable intelligence. Based on the detailed recommendations in the Computer Law Group newsletter, if you are operating in this digital economy today, what should you actively be doing with this intel?
The newsletter breaks the actionable advice down by sector. Let's start with platform clients.
Companies that rely on securing must-have access points, like device manufacturers or telecom carriers.
Right, or major software distributors. The advice here is urgent and unequivocal. Audit your default placement and pre-installation agreements immediately.
What are they looking for in that audit?
The newsletter explicitly states that exclusivity clauses are antitrust dynamite in 2026. The legal winds have shifted permanently.
So you can't just lock things down anymore.
No. You can no longer lock up a distribution channel indefinitely. You need to immediately substitute exclusive structures with non-exclusive limited-term agreements.
So if I run a telecom company and I want to preload a specific streaming app on all my phones, I can't sign a 5-year exclusive deal anymore.
Right. Cap those deals at a 1-year duration. Ensure the contracts include explicit written freedom, allowing your counterparty to preload rival applications alongside yours.
You have to demonstrate that you are not artificially closing the door behind you.
Exactly. You must leave room for competition.
What about for the AI startups and the search rivals? The companies trying to build the next generation of discovery tools.
For them, this ruling is a massive regulatory tailwind, but they have to act to capture it. Startups need to be monitoring Judge Mehta's technical committee obsessively.
Because they are the ones handling the data sharing.
Yes. The committee is expected to publish its formal intake procedures and data security protocols in the second half of 2026.
So they need to get in line.
They need to get their engineering and compliance teams ready to apply for the official designation of a qualified competitor.
Because if they get that designation...
Because if you achieve that status, you suddenly gain access to Google's foundational search index and user interaction data on ordinary commercial terms.
That's huge. That represents a multi-billion-dollar subsidy in raw data that you can use to train your own specialized algorithms.
It is an incredible opportunity for a startup.
What about for advertisers and web publishers, the people actually buying the ads or relying on the traffic?
For them, the dual liability findings from Judge Mehta regarding search in D.C. and Judge Brinkema regarding ad tech in Virginia are an absolute game changer for civil litigation.
Why does a government victory help a private advertiser?
Because of a legal concept called prima facie evidence.
Prima facie evidence, explain that.
Normally, if a private company wants to sue Google for antitrust violations, they have to spend $50 million in 5 years just proving that Google is a monopoly. It is prohibitively expensive.
Right.
But under federal law, a final judgment against a defendant in an action brought by the United States can be used as prima facie evidence against that defendant in any subsequent private lawsuit.
Meaning the private company can walk into court, point at Judge Mehta's ruling, and say, the government already proved they're an illegal monopoly. I don't have to prove that part again. I can skip straight to proving how much money they overcharged me.
Exactly. The foundational groundwork for massive private damages class actions against Google's advertising stack has already been laid and paid for by the DOJ.
Finally, what about investors and corporate strategists? How should they be modeling the risk of this appeal?
The newsletter suggests the most statistically probable outcome, the base case, sitting at roughly a 65 to 70% probability, is that the D.C. Circuit Court makes only modest modifications to Judge Mehta's ruling in mid-2027.
So plan for the behavioral remedies to stick.
Yes. Model your strategies, assuming the data sharing mandates will go into effect, and assume the ban on exclusive default contracts is permanent.
But don't bet on a breakup.
Crucially, do not base your investment thesis on a structural breakup. Do not hold your breath waiting for a Chrome spinoff or an Android divestiture.
Because the cross-appeal dynamic, where the DOJ is demanding a breakup and Google is demanding total exoneration, actually makes the judge's calibrated middle-path behavioral decree the most legally defensible position to survive appellate review.
Precisely. The surgical approach is the one most likely to survive the appellate process intact.
This has been an absolutely incredible journey through the mechanics of the law. We started by looking for a broken bone on an X-ray, and we have ended up mapping out a global chessboard of antitrust frameworks, artificial intelligence disruption, and billion-dollar corporate survival strategies.
It is an incredibly complex landscape, but understanding the specific mechanics of this appeal and why the judge made the cuts he did is absolutely essential for anyone trying to navigate or operate within the digital economy today.
As we wrap up this deep dive, there's one final lingering thought that I keep marveling at, and I want to leave you, the listener, with this to ponder.
It's a great thought experiment.
We mapped out the timeline. The newsletter projects that the D.C. Circuit rules in 2027, and the Supreme Court won't definitively settle this case until maybe 2028 or 2029.
Years from now.
Think about how extraordinarily fast technology is moving right now. OpenAI has 900 million users today. They are processing billions of complex prompts a day.
The landscape is shifting under our feet.
The question is, by the time the Supreme Court finally issues a ruling in 2029, will the legal definition of monopoly maintenance in general text search even matter? Or will the sheer velocity of generative AI have already completely rewritten the fundamental architecture of how humans access information, rendering this entire decade-long legal battle obsolete while the courts were still arguing over the paperwork?
It is a staggering race between the speed of innovation and the speed of the law.
It really is.
Led by Jack Russo, Computer Law Group LLP is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at computerlaw.com and his team at www.computerlaw.com, where the newsletter we referred to is published in detail and readily available, commitment-free with no paywalls or other charges.
Tune in next time on The Valley Current.